I don't want to be mean, but you're kind of a mess. You know that? You showed up drunk in court back in May. People against Derek Allen Makunovich, and I'm going to need the victim in here on this one, 242-642-916. And I'm going to need Jessica in here on this one. Okay, your appearance?
Michael Crawford.
Your name?
Derek.
Failure to pay fines and costs is ordered 631. Failure to refrain from having contact, direct or indirect, with Danielle Lowler. And failure to register for, attend, and complete the anger management class with 8-week follow-up. He already has 7 prior technical violations. If he pleads guilty to any one of these, his probation could be revoked. He could be incarcerated for a period of 90 days. How is he going to proceed?
Your Honor, my fellow plead guilty to each of the allegations with explanation.
Is that what you want to do, sir?
Yes, ma'am.
If you plead guilty again, you could get 93 days. There's 3 of them. You understand 90 days with credit for any time already served. You understand that?
Yes.
Did you sign the advice of rights?
Yes.
Did you read it and understand it?
Yes, sir.
You understand if you plead guilty, you'll be giving up all those rights and there will not be a hearing nor a trial. Do you understand that?
Yes, sir.
As to the first count that you failed to pay your fines and costs as ordered, how do you plead?
Guilty.
Did you fail to pay your fines and costs as ordered?
Guilty.
Did you fail to pay them
Yes.
as ordered? Yes?
Yes.
As to count 2, that you failed to refrain from having contact, direct or indirect, with Danielle Lowler, how do you plead?
Guilty.
Did you have, sir, did you have contact with Danielle Lowler?
Yes. Over through good night call. Yes.
Did it have anything to do with the children?
Yes, it did.
All of the contacts had something to do with the children?
Yes.
They did?
Yes.
Then why are you pleading guilty? Didn't I say you could have contact with, to effectuate visitation?
It could be this. It wasn't over the at close.
Hang on a second. Yeah, your name. I don't want to hear from you yet, though. I just want to know, when you had contact, was it strictly about the children? Yes or no?
Yes.
It was? Is that right? It was? Any contact that you had was a text about the children? Because I think that I said, let me double check.
There
Hang on a
There
second.
may have been one that I should have. I can't remember exactly which one.
Okay, so
Short and sweet.
I said, no contact with Lawler except in conjunction with circuit court proceedings. Not to be within 2 miles of her residence or place of employment except when picking up or dropping off the children. So I guess I did not, unless it had something to do with the circuit court proceedings, allow you to have contact. What kind of contact did you have with her, sir? What did you, I don't want you to be generic about it. What, if any, violation occurred when you weren't talking to her, just to give you the benefit of the doubt about the children or visitation, pickups or drop-offs?
Mainly what I do over the app close, when she fails to respond over the app close, screenshot it and then send it over Facebook Messenger.
Okay, good. But what was the dynamics of the conversation?
It's been years over like Ellie's gymnastics schedule, dance schedule, things going on for pictures.
That's it? Nothing else?
There was one where I said like, please stop being spiteful.
Okay.
There was that one that I should not send.
And is the count three that you violated probation in the sense, register for, attend, and complete the anger management program? How do you plead to that?
Guilty.
Slow
I
down.
was working with.
Slow down.
Went under.
Slow down. Did you register for or attend the anger management program with 8-week follow-up?
No.
And I ordered you to do that August 1 of 24, right?
Yes.
Anybody forced you to plead guilty?
No.
You still wish to plead guilty to all 3 counts?
Yes. Your Honor.
Pleas are accepted to all 3 counts. I'd like Ms. Lawler up here. I don't know, you got your work cut out for you on this one. Mr. Crawford?
Indeed.
Your name, ma'am?
Danielle Rutler.
What is it? Tell me. Let's talk about the easy one, the fines and costs. Why isn't he paying them? Why didn't he come and talk to me?
Well, the reason he's not paying, hasn't paid, Your Honor, the financial reason for the whole household. Wife was out of work. She was the primary breadwinner for several months. She didn't have the money. And then the nature of his work had stopped because it became the off season. She just got back to work the past couple of weeks. The wife just started working at the end of September, Your Honor. They're now in position to start paying these things and moving forward, but that's been the holdup for one period.
I don't want to be mean, but you're kind of a mess. You know that? You showed up drunk in court back in May. I told you multiple times, like I tell everybody, that you have the right to come and talk to me. I'll be glad to give you an extension. I don't know how many times I've said that to people and how many times that they haven't taken me up on it, which I don't get. But you were supposed to pay $75 bi-weekly, starting back in August of 24. That's $150 a month. That's $1,800 over 12 months. I only fined you $921.44. And unless you've made a payment since the show cause was issued, you still owe us $631.45. And that means, in my view, unless I assess costs, and I probably did in conjunction with some of the other violations, that you're only, let's see, 631 from 921, you're only $290 less than what I had originally fined, and we're 14 months into a case. Let's talk about count 2. Why didn't he comply with what? Let's let you tell me what he did or didn't do. Ms. Lawler, would you like to tell me something?
So there are, what's in place with the custody order, which you allowed to remain in place, is that one custody order states that our nightly video calls to say goodnight to our child happens over the Facebook Messenger, FaceTime thing for approximately 10 minutes. So when I have Ellie, he gets the call. When he has Ellie, I get the call. We do the same thing. And it's only for the video calls. There's no communicating with each other during those calls. There's no talking to each other during those calls. It's only meant for child and parent.
And that's something the circuit court judge put in
Yes.
effect. Okay.
The other thing we have in place through third circuit court is a referee recommendations by the judge as well that mandates all written communications be through app books. So he still, now I do not respond to messages even within the app that are harassment, threats, name calling,
Do you have a copy of any of them? Can I see them?
not with me. I didn't.
You have them?
The ones through the app close because technically they're allowed to communicate through the app close. I have the ones he sent her via the Facebook Messenger, including a spiteful message that I have that one at the very top if you'd like to take a look.
Let me see.
If I'm on it. My client was stipulating and agreed that during these communications about the child, he did sometimes go outside the bounds a bit in terms of voicing his frustration about the non-responsiveness he felt that the mother was purposefully carrying out in these communications. I explained to him in this context, that's completely inappropriate. You have to keep your focus just on issues related directly to the child only, not your comments or editorial about how she is facilitating the communication. And I think when the court takes a look, that's what you'll kind of see, a kind of a frustration around his attempts to communicate to his daughter. And him feeling that mom is either obstructing or not taking the necessary steps to make sure that's happening a bit more smoothly. Again, he better understands that although that's about his daughter, that's really about his opinion about how the mom was facilitating his communication. I talked with him extensively and his wife
Let me
extensively.
take a look at these first. I apologize, but what is the spiteful one again?
It's the one on the very first page at the bottom, that long message at the bottom there.
All right, I'm having a heck of a time.
Sorry.
I've seen worse, Mr. Pakunovich, but it doesn't mean you can fail to comply with orders.
Won't happen again.
Judge, I'd also like to add, there was the most recent message on Facebook Messenger, where the defendant sent to the victim regarding their daughter. Their daughter's name's Ellie. He said, please have Ellie call me from her phone, not the Facebook Messenger account, which is again, how we're supposed to do the video calls through the Facebook Messenger account. So again, I'm not sure what he's trying to get at going against that.
Well, again, Your Honor, this all has to do with trying to be able to communicate reliably with his daughter. Again, I explained to him, although if they had the best of intentions, technically it's likely violative of the order. They got her an additional phone as a reward for getting some good grades, but it's a special child phone where it's monitored, she won't do certain things. And the hope was that they'd be able to do the Facebook Messenger directly through this phone and more reliably communicate with the daughter like the court order says. But again, I explained to him, the court order should be followed as read and interpreted quite narrowly, that you communicate through Facebook Messenger, that the mom initiates and involved in, and or through the app. So again, he's got some frustration with how mom is either purposely or inadvertently frustrating this communication attempt. In his opinion, I explained to him the best place for him to get this cleared up is in family court. He's not helping himself here in this matter and trying to interpret these things on his own and in his household.
I have another set of messages as well, Your Honor, but most of these are just showing their back and forth video call over Facebook Messenger and showing that the defendant will often then take screenshots of what it looks like the app closed and send her through Facebook Messenger.
He does that, Your Honor, again, because she's not responding through the app. So he's taking a picture that he's trying to communicate through the app, it's ordered by the court, and he's sending it through Facebook Messenger, just trying to communicate. I explained to him again, by the letter of the order, probably not right either, but these are all attempts to communicate with her about the child or the child directly. We stipulated again in a couple of these communications, he did voice his frustration about this dynamic. And I told him that's inappropriate. He knows that now. I would hope the court would not consider taking away his freedom since he's just getting back to work over this violation. He might be a bit hard-headed here, a little stubborn in trying to interpret and follow the order. But he gets it now. We're taking great pains in trying to help him understand how to better comply with that order and thus not be bothered.
What date does his probation end?
November 1st, Your Honor, this year.
She's pretty darn close.
Do you realize now that you've had 10 violations? 10. I mean, I'll grant you that a couple of them were failure to report, different.
So I do everything I can to,
You're not doing enough.
there today, I can make sure that this won't happen again.
Judge, if I could regarding the violation regarding the ignorant misstatement class, he was told that he had to register for the one in August. That was gonna be his last opportunity to get registered, attend and completed in time. He failed to do so, did not register, did not attend. The next one available is not gonna be till at least December, and it's gonna take him at least 2 weeks to get, or to have 2 months, I'm sorry, to get completed once within it too, so.
In Your Honor, he simply couldn't pay for it. The wife was unemployed for 7 months. She was injured. Work wasn't available for him. They were just hanging on by tooth and nail. He couldn't pay for it. But now he can. If the court would be so kind, if it's possible, to extend it, and he's going to get registered today.
Yes,
They've got the money.
Well, now all of a sudden he's got the money.
Well, it's not all of a sudden, Your Honor. It is the nature of the facts. The wife just got back to work at the end of September. He just started 2 weeks ago.
Well, she didn't get back to work since the end of September. She hasn't had a paycheck yet. Here's what I'm doing. probation's extended for a period of 4 months until March 1 of 26. You're to pay additional probation fees of 80, additional costs of 75. You're to attend the anger management program with 8-week follow-up. You are to serve 7 days jail forthwith. This is your last opportunity to play this game with me or nonsense again with her. You're going to get max time, sir. I wish you well. Good luck. Have a great day. Thank you very much. You're in custody. And I'm going to give you, Mr. Makunovich, you realize you're in custody for 7 days, right?
Yes.
Okay. I'm going to give you time to pay on this. You can pay this by November 1. If you don't get into that class again, I'm telling you, you're going to get max. I wish you well. Ms. O'Donnell, take these documents back. You have a seat in the jury box. So follow my court officer's direction.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.